The woman standing at my front door looked like she had just discovered I was running a meth lab instead of a propane delivery business. Her tightly wound blonde hair and pressed lavender cardigan screamed suburban authority, and the clipboard in her hands might as well have been a weapon. "You cannot continue operating a commercial vehicle from this residential property," she announced, not even bothering with a hello. "I'm Patricia Henderson, president of the Meadowbrook Estates HOA, and your business is in direct violation of our covenants." I stood there in my work boots, still covered in the grime from filling tanks all morning across Fairfax County, Virginia, trying to process what was happening. I had lived in this house for 27 years. My father, Xavier Bennett Sr., had bought this property back in 1978, and when he passed 15 years ago, it became mine. I was Xavier Bennett Jr., though everyone called me Xander, and I had been running Bennett Propane services from this same address since 1998. "Madam, I think there's been a misunderstanding," I said, keeping my voice level. "I've been operating my business here for over 2 decades, never had a problem before." Patricia's eyes narrowed like a hawk spotting a field mouse. "Well, you have a problem now. We have rules in this neighborhood, Mr. Bennett. Rules that everyone must follow. No commercial vehicles parked overnight, no business operations conducted from residential properties, and certainly no industrial equipment stored on premises." I glanced past her at my white Ford F-350 with the Bennett Propane Services logo on the side. It was parked in my driveway, same as it had been every night for years. Behind my house, in a properly fenced and secured area, I kept several empty propane tanks waiting for refills and my equipment. "I have all the proper licenses and permits," I explained. "The county approved my business operations years ago. The county isn't in charge of our neighborhood standards," Patricia snapped. "The HOA is. And I'm telling you right now, you have 30 days to cease all business operations from this address or face daily fines of $250. She thrust a packet of papers into my hands and turned on her heel, walking back to her pristine silver Lexus SUV parked on the street. I watched her drive away, feeling like I'd just been hit by a truck. Inside, I sat at my kitchen table and read through the papers. Sure enough, there were citations for multiple violations, threats of liens against my property, and references to covenants and restrictions I'd never heard of. According to the documents, the Meadowbrook Estates HOA had been established in 2018 when a developer bought several surrounding properties and built new homes. They claimed jurisdiction over all properties within certain boundaries, including mine. That didn't make sense. My property had been here long before 2018, long before any HOA existed in this area. I called my neighbor, Tom Richardson, who had lived 2 houses down for almost as long as I had. He picked up on the third ring. "Tom, did you know we're supposedly part of an HOA now?" I asked. Tom groaned. "Oh, you met Patricia?" "Yeah, she came by here last month threatening me over my kid's basketball hoop. Said it was an eyesore. I told her where she could stick her covenants." "Did you sign anything? Agree to join?" "Hell no. I told her I wasn't interested." "She said it didn't matter, that all properties in the development boundaries automatically fall under their rules." "That can't be legal," I said. "Probably isn't, but who has the time and money to fight it? I just took the basketball hoop down. Easier than dealing with her." But this wasn't a basketball hoop for me. This was my livelihood. Bennett Propane Services provided fuel for residential heating, generators, pool heaters, and outdoor cooking equipment all over Fairfax County. I had 12 regular commercial clients and over 200 residential customers who depended on me. I employed 2 part-time drivers during the busy winter months. This wasn't a hobby. This was how I paid my mortgage and put food on my table. The next morning, I drove to the Fairfax County Government Center to figure out what my options were. The clerk at the business licensing department was a middle-aged woman named Gloria, who had actually processed my original business license back in 1998. "Gloria, I need your help," I said, explaining the situation. She frowned, pulling up my records on her computer. "Your business license is current and in good standing. You've never had a violation or complaint filed in 27 years. That's actually impressive. The HOA is saying I can't operate from my property. You have a copy of their charter or incorporation documents?" I realized I didn't. Patricia had given me the violations but not the actual HOA governing documents. Gloria typed some more. "Let me see what I can find. What's the HOA called?" "Meadowbrook Estates, HOA." Her fingers flew across the keyboard. After a few minutes, she nodded. "Found it. They incorporated with the state in March 2018. Their boundaries include..." She squinted at the screen, portions of Maple Avenue, all of Brookside Drive and the surrounding area. "My property is on Maple Avenue," I said, "but I've owned it since way before 2018. My father bought it in 1978. Gloria looked up at me. "Then you might have a grandfathering situation. If your business license predates their charter, they likely can't enforce these restrictions on you. Let me print out your complete business history." She disappeared into a back room and returned with a folder full of documents. My original business license from 1998, renewal records, county permits for propane storage and handling, zoning approvals, everything. She also included a property deed search showing continuous ownership since 1978. "One more thing," Gloria said. She went to a different terminal and pulled up another document. "This is the official HOA charter filed with Virginia. Look at Section 12. I read where she pointed. The section outlined which properties were included in the HOA. It specifically stated that the HOA governed all properties within the development boundaries, purchased after March 15, 2018, or any property whose owner voluntarily agrees to join. I didn't purchase after that date, and I sure didn't voluntarily join," I said. "Then legally, I don't think they have any authority over you," Gloria said. "But I'm not a lawyer. You should probably consult one." I thanked her and left with my folder of ammunition. But lawyers cost money, and I wasn't eager to drain my savings on legal fees if I could avoid it. I decided to try reasoning with Patricia first, armed with proof that my business predated her HOA by 2 decades. I called the number on the violation notice. Patricia answered on the first ring. "Mrs. Henderson, this is Xavier Bennett. I'd like to discuss the violations you issued." "There's nothing to discuss, Mr. Bennett. Either comply or face the fines. I have documentation from the county showing my business license was issued in 1998, 20 years before your HOA existed. I also have proof that my property ownership goes back to 1978. Your own charter says you only govern properties purchased after 2018 or those that voluntarily join. I don't fall into either category." There was a long pause. "That's not how this works," Patricia finally said, her voice tight. "When the HOA boundaries were established, all properties within those boundaries became subject to our authority. It doesn't matter when you bought your property. That's not what your charter says. Our charter is supplemented by Virginia HOA law, which grants us broad authority to maintain neighborhood standards." "I'd like to see where exactly the law says that," I said, "because the county clerk seems to think you don't have authority over pre-existing properties and businesses." Patricia's voice went ice cold. "Mr. Bennett, I suggest you comply with the violations or prepare for legal action. We have an attorney on retainer, and we will pursue this to the fullest extent." Your first fine of $250 will be assessed on May 1st if you haven't ceased operations. Good day." She hung up before I could respond. Over the next week, I tried to go about my business as usual, but the stress gnawed at me. I couldn't afford $250 a day in fines. That was over $7,000 a month. Even if the fines weren't legally enforceable, fighting them would cost money I didn't have. On April 30th, I received a certified letter from a law firm in Arlington. The letter, signed by an attorney named Marcus Webb, reiterated the HOA's demands and stated that if I didn't comply, they would file for a court injunction to stop my business operations and place a lien on my property for unpaid fines. That night, I barely slept. I kept thinking about my father, about how he'd worked 2 jobs to afford this house, about how proud he'd been when I started the propane business. He'd always said, "Find something people need, do it well, and you'll never go hungry." Propane delivery was exactly that. Simple, essential, honest work. The next morning, I found a notice taped to my front door. It was an official-looking document with the HOA letterhead, stating that as of May 1st, I was being fined $250 per day for continued violations. The document included photos of my truck in the driveway, time stamped from the previous evening. That was it. I was done trying to handle this alone. I found a lawyer through a friend's recommendation. Her name was Denise Volker, and she specialized in property law and HOA disputes. Her office was in downtown Fairfax, in a brick building that had been converted from an old bank. The reception area still had the original vault door visible in one wall. Denise was probably in her mid-50s, with short silver hair and sharp green eyes that reminded me of my high school geometry teacher. She had the same look of someone who could spot flawed logic from a mile away. I laid out the entire situation, providing copies of all the documents Gloria had given me, plus the violation notices and the letter from the HOA's attorney. Denise read through everything carefully, making notes on a yellow legal pad. After about 20 minutes, she looked up at me. "This is pretty straightforward, actually. The HOA doesn't have a leg to stand on." Relief flooded through me. "Really? Really? Look, HOAs in Virginia have to follow specific laws about formation and jurisdiction. They can't just decide they govern a property without either the owner's consent or a legitimate legal claim. Your property predates their formation by 40 years. Your business predates their formation by 20 years. And their own charter explicitly limits their authority to properties purchased after their formation date, or those that voluntarily join. Patricia said Virginia law gives them broad authority." Denise smiled. "Patricia is either misinformed or deliberately misleading you. Virginia law does give HOAs certain powers, but not the power to retroactively claim jurisdiction over properties that aren't part of their development. Did you ever receive any disclosure documents when they formed? Any notice that your property was being included?" I thought back. No. I didn't even know the HOA existed until Patricia showed up at my door. That's another problem for them. Virginia law requires HOAs to provide notice to affected property owners. They didn't do that because they knew they didn't have actual authority over your property. She tapped her pen on the papers. "Here's what we're going to do. I'll draft a response to their attorney explaining why their claims are invalid. I'll cite the relevant Virginia code sections, their own charter language, and your documented history. I'll also demand they cease harassment and retract the fines. What if they don't? Then we file a declaratory judgment action asking a court to officially rule that your property isn't subject to the HOA's authority. Given the facts here, I'd say we have better than 95% chance of winning. But I don't think it'll come to that. Once their attorney sees our response, he'll advise them to back off. How much is this going to cost me? My initial letter will be $1,500. If we have to file suit, we're looking at probably $5,000 to $8,000 total, but we can also ask the court to award us attorney's fees since their claims are baseless. You might end up paying nothing. $1,500 was a lot, but it was better than $7,000 a month in fines. I agreed, and Denise said she'd have a letter ready within 3 days. True to her word, 3 days later she emailed me a copy of her response letter. It was 4 pages of dense legal language that basically said the HOA could pound sand. She cited Virginia Code Section 55.1 through 55.1 1900, which governed HOAs. She quoted their own charter back at them. She included affidavits from the county clerk's office confirming my business license history. The last paragraph was my favorite. Mr. Bennett's property and business operations are not subject to the Meadowbrook Estates, HOA's authority, and any attempt to enforce fines, file liens, or otherwise interfere with his lawful business will result in litigation for harassment, abuse of process, and malicious interference with business operations. We trust you will advise your client to cease this meritless action immediately. Denise sent the letter via certified mail and regular email to both Marcus Webb and Patricia Henderson directly. 2 days later, my phone rang. It was Marcus Webb. "Mr. Bennett, I received Miss Volker's letter," he said. His voice was professional but strained. "I've reviewed the situation with my client, and there seems to be some confusion about the scope of the HOA's authority." "No confusion on my end," I said. "I'm not part of your HOA." "Yes, well, that's a matter of interpretation." The HOA believed in good faith that all properties within the development boundaries. "Their charter says otherwise," I interrupted. "And Virginia law says otherwise, and common sense says otherwise." Webb sighed. "I'm trying to resolve this amicably, Mr. Bennett. Perhaps we could arrange a meeting between you, Mrs. Henderson, and the HOA board to discuss this." "What's there to discuss? Either I'm subject to your authority or I'm not. My lawyer says I'm not. Your client's own documents say I'm not, so retract the fines and leave me alone." "It's not quite that simple. The HOA has concerns about neighborhood standards, not my problem. I was here decades before the HOA existed. I'm running a legal, licensed business with all proper permits. If they don't like it, they can move." Webb was quiet for a moment. "I'll discuss this further with my client, but I should warn you, Mrs. Henderson is quite determined to enforce what she sees as the community's rules. Then she's going to lose a lawsuit and probably have to pay my attorney's fees on top of it." After we hung up, I felt a small surge of victory. But I also knew this wasn't over. People like Patricia didn't give up easily. Sure enough, the next week brought a new development. I came home from a delivery run to find a county inspector in my driveway, examining my propane storage area. "Can I help you?" I asked, approaching cautiously. The inspector, a young guy in his 30s with a county ID badge, looked up. "I received a complaint about improper storage of hazardous materials at this address. I'm conducting an inspection." "I have all the proper permits for propane storage," I said. "Always have." "I'm sure you do, but I still need to verify compliance with current regulations." I showed him my permits and walked him through my storage setup. Everything was by the book: proper fencing, adequate ventilation, correct spacing from structures, fire extinguishers, warning signs, the works. I'd been doing this for 27 years, and safety was always my top priority. After an hour, the inspector finished his checklist. "Everything looks good, Mr. Bennett. You're in full compliance. I'll file my report." Who made the complaint? I asked. He hesitated. I'm not supposed to say, but it was filed by a Patricia Henderson on behalf of the Meadowbrook Estates HOA. She claimed you were storing dangerous materials in violation of safety codes. And clearly I'm not. Correct. Have a good day. After he left, I called Denise and told her what happened. Document everything, she said immediately. Keep a log of every interaction, every phone call, every letter. This is harassment and it's building our case. You think it'll come to that? I'm starting to think it might. Patricia sounds like the type who doesn't know when to quit. She was right. Over the next 2 weeks, I received 3 more visits from various county departments. Someone complained about my business signage, claiming it was too large. It wasn't. Someone complained about commercial traffic, claiming I was operating a shipping depot. I wasn't. Someone complained about noise, claiming I was running machinery at all hours. I wasn't. Every single complaint was baseless. Every single inspection cleared me. And every single complaint came from Patricia Henderson on behalf of the HOA. My regular customers started asking questions. Mrs. Chen, an elderly woman whose home heating I'd been servicing for 15 years, called me in distress. Xavier, someone came to my house asking questions about your business, she said. A blonde woman. She wanted to know if you'd ever had problems, if your equipment ever failed, if I'd ever felt unsafe. She made it sound like you were doing something wrong. Mrs. Chen, I promise you, everything is fine. There's just a dispute with an HOA. It has nothing to do with my work. She scared me, Xavier. She said propane was dangerous and that I should consider switching to electric heating. Propane is safe when handled properly, which I always do. You know that. Have I ever given you reason to worry? No, never. You're always so careful and professional. I just wanted to let you know what she said. After we hung up, I was furious. Going after me was one thing, but going after my customers, trying to damage my reputation and scare people, that crossed a line. I called Denise again. We need to do something. She's contacting my customers now, making false statements about my business. That's tortious interference and defamation, Denise said. We can sue for that, but let me try one more thing first. I'll request a formal meeting with the HOA board and their attorney. I'll make it very clear that if they continue this harassment, we'll file a lawsuit that includes not just the HOA but Patricia Henderson personally for her actions. The meeting was scheduled for the following Tuesday evening at the Meadowbrook Estates clubhouse. I'd driven past the place 100 times but never been inside. It was a modern building with glass walls and expensive landscaping, paid for by HOA dues from residents who'd actually chosen to live in the development. Denise and I arrived together. In the conference room, we found Patricia Henderson, 2 other board members, and Marcus Webb. Patricia's expression was pure ice when we walked in. Thank you for agreeing to meet, Webb began. I think we can resolve this situation without litigation if everyone's willing to be reasonable. I'm always reasonable, I said. I just want to be left alone to run my business in peace like I have for 27 years. One of the other board members, a man in his 60s named Gerald, spoke up. Mr. Bennett, we're not trying to put you out of business. We're just trying to maintain property values. Commercial operations in a residential neighborhood can impact home prices. My business was here first, I said. If property values are affected, people knew that when they bought here. Besides, my operation is clean, quiet, and safe. I'm not running a junkyard. Patricia leaned forward. That's not the point. The point is that we have standards and you're flagrantly disregarding them. Standards I never agreed to, I shot back. Standards that legally don't apply to me. Denise held up a hand. Let's focus on the facts. Mr. Bennett's property predates the HOA. His business license predates the HOA. The HOA's own charter limits its authority to properties purchased after formation or those that voluntarily join. Mr. Bennett falls into neither category. Therefore, he's not subject to HOA authority. This is black and white. Webb cleared his throat. The HOA's position is that when the development boundaries were established and filed with the county, all properties within those boundaries became subject to HOA governance, regardless of when they were purchased. "Show me the law that says that," Denise challenged. Webb hesitated. "It's a matter of legal interpretation." "No, it's not. Virginia code is clear. An HOA's authority derives from either deed restrictions recorded at purchase or voluntary agreement to join. Mr. Bennett's deed has no such restrictions because the HOA didn't exist when his father purchased the property, and he's never agreed to join. You have no authority over him, period." The room was tense and silent. The third board member, a woman about my age named Lisa, finally spoke. "So what happens now? We just let him do whatever he wants." "He's doing what he's legally permitted to do," Denise said. "He has all required county licenses and permits. His operations comply with all zoning and safety regulations. What you want is irrelevant." Patricia's face flushed red. "This is exactly the kind of arrogance we're talking about. People who think rules don't apply to them. Rules don't apply when they're not legally enforceable," I interrupted. "And yours aren't. Not to me." Webb tried to regain control of the meeting. "Perhaps we could reach a compromise. If Mr. Bennett would agree to certain limitations on his operations, modified signage, restricted parking hours, something, then the HOA could withdraw its complaints." "No," I said flatly. "I'm not compromising on my legal business operations because Patricia doesn't like how my truck looks." "This meeting is over unless you're prepared to retract all fines and cease harassment." Patricia stood up abruptly. "Fine. We'll see you in court, Mr. Bennett, and when we're done, you'll wish you'd been more cooperative." "Is that a threat?" Denise asked sharply. "It's a promise," Patricia said, grabbing her purse and walking out. The meeting dissolved after that. Webb looked embarrassed as he gathered his papers. "I'll be in touch," he said vaguely. Outside in the parking lot, Denise turned to me. "Well, that went about as badly as possible. What do we do now?" "We file our declaratory judgment action. We ask the court to rule that you're not subject to HOA authority, and we file counterclaims for harassment, defamation, and tortious interference based on Patricia's campaign against you. We go on offense." "How long will that take?" "Could be 6 months to a year before we get to trial. But we can also file for a preliminary injunction to stop the HOA from interfering with your business in the meantime." "Do it," I said. Over the next month, the legal war escalated. Denise filed our lawsuit in Fairfax County Circuit Court. The HOA responded with a counterclaim alleging that I was operating a nuisance business and seeking an injunction to shut me down. We filed for our preliminary injunction. They opposed it. Meanwhile, Patricia's harassment continued. She filed more complaints with county departments. She sent letters to all my known customers claiming my business was operating illegally. She even posted on social media neighborhood groups warning people about unsafe propane operations on Maple Avenue. Each incident got documented. Each false statement got cataloged. Our case file grew thicker every week. The hearing for the preliminary injunction was scheduled for late August. Judge Raymond Morrison presided. He was a stern-looking man in his 70s who'd been on the bench for 30 years. His reputation was for no-nonsense, by-the-book rulings. Denise presented our case first, walking through my property history, business license history, and the HOA's clear lack of authority under both their own charter and Virginia law. She submitted all the documents from the county clerk, including my original business license from 1998 and the property deed from 1978. Your Honor, this is one of the clearest cases I've ever handled, Denise argued. The HOA simply has no jurisdiction over Mr. Bennett's property. Their own charter admits as much. They're attempting to enforce rules that they have no legal right to enforce, and in doing so, they're damaging Mr. Bennett's business and harassing him. We're asking this court to enjoin them from any further interference while the underlying case proceeds. Marcus Webb argued for the HOA, but his heart didn't seem in it. He tried to claim that the HOA had broad authority over all properties in the development boundaries, but when Judge Morrison asked him to cite specific legal authority for that proposition, he struggled. Your Honor, the Virginia Property Owners Association Act grants HOAs substantial powers to enforce community standards. Does it grant them power over properties that aren't part of the association? Judge Morrison interrupted. The HOA takes the position that all properties within the boundaries are part of the association. Based on what? Mr. Bennett never signed anything. His deed has no restrictions. Where does your authority come from? Webb fumbled through his papers. When the development was platted and filed with the county, the boundaries were established. That doesn't answer my question. Show me the law that says filing a development plat gives you authority over pre-existing properties. Webb couldn't, because that law didn't exist. Judge Morrison looked annoyed. Mr. Webb, I've read the briefs. I've reviewed the HOA's charter. Unless you can show me something I'm missing, it appears your client is attempting to enforce covenants against someone who never agreed to them and isn't legally bound by them. That's not how contract law works. Your Honor, with respect, this is a complex area of HOA law. It's not complex at all. Either Mr. Bennett is bound by your covenants or he isn't. The burden is on you to prove he is. Can you do that? Webb hesitated. We believe the full trial will allow us to more thoroughly present. That's a no. Preliminary injunction granted. Judge Morrison banged his gavel. The HOA and its board members are enjoined from interfering with Mr. Bennett's business operations, filing complaints with county agencies regarding Mr. Bennett's business, contacting Mr. Bennett's customers, or assessing fines against Mr. Bennett pending resolution of this case. Next matter. We walked out of the courthouse into the bright August sunshine. I felt like I could breathe for the first time in months. That was incredible, I said to Denise. That was a judge who's tired of HOA overreach, she replied, but don't celebrate too much yet. We still have the full trial to get through. The injunction just stops them from harassing you in the meantime. Will they actually comply? They'd better. Violating a court order is contempt. That means fines and potentially jail time. For a few weeks, everything was quiet. Patricia didn't contact me. No more county inspectors showed up. My customers stopped reporting visits from mysterious blonde women. I started to think maybe it was actually over. Then I received a certified letter that made my blood run cold. It was from a different law firm, not Marcus Webb's. This firm specialized in HOA collections. The letter stated that despite the pending litigation, I owed the Meadowbrook Estates HOA over $16,000 in unpaid fines from May, June, and July. They were demanding immediate payment and threatening to foreclose on my property through a lien. I called Denise immediately. They're violating the injunction, she said after I read her the letter. Judge Morrison specifically ordered them not to assess fines. We're filing a motion for contempt. Can they really foreclose on my house? Not if they don't have authority to fine you in the first place, which they don't. But yes, if left unchecked, an HOA can absolutely foreclose for unpaid fines and fees. It's one of the most aggressive powers they have. That's why we need to shut this down now." The contempt hearing was expedited and held 2 weeks later. Judge Morrison did not look happy when he read our motion. Patricia and the 2 other board members, Gerald and Lisa, were all present. Marcus Webb was back representing them, along with an attorney from the collections firm. "Mrs. Henderson," Judge Morrison said, his voice hard. "Did you or did you not understand my order from August?" Patricia stood up, her face defiant. "Your Honor, we understood the order, but we felt we had an obligation to our community members to continue pursuing legitimate debts. Legitimate debts. I specifically ordered you not to assess fines against Mr. Bennett. How is $16,000 in fines not a violation of that order? The fines were assessed before your order. The letter demanding payment was sent after my order. The threat of foreclosure came after my order." "That's contempt, Mrs. Henderson." Webb stood up quickly. "Your Honor, if I may, there was some confusion within the board about the scope of the injunction. There was no confusion. My order was crystal clear. The HOA is attempting to do an end run around my ruling by hiring a collections firm to do what I told them they couldn't do themselves." The collections attorney tried to speak, but Judge Morrison cut him off. "Save it. I'm expanding my injunction. The HOA and any agents acting on their behalf are prohibited from attempting to collect any fines from Mr. Bennett, filing any liens against his property, or threatening foreclosure. Furthermore, I'm ordering the HOA to pay Mr. Bennett's attorney's fees for this contempt motion. Mrs. Henderson, if you appear before me one more time for violating my orders, I will hold you personally liable and consider criminal contempt charges. Do I make myself clear?" Patricia's face went white. "Yes, Your Honor." "Good. This case is set for trial in January. I suggest you use the time between now and then to seriously reconsider your position." Dismissed. As we left the courtroom, I saw Patricia in the hallway, arguing in heated whispers with Marcus Webb. He looked exhausted and fed up. I didn't blame him. Representing a client who ignores court orders is a nightmare for any attorney. "That was even better than last time," I said to Denise. "It was necessary. HOAs that ignore court orders are dangerous. They get used to having power, and they forget they're still subject to the law." Fall passed slowly. My business continued as usual. The injunction held. Patricia and the HOA left me alone, though I occasionally saw Patricia driving past my house slowly, glaring at my truck. In December, we were notified that the trial was scheduled for January 15th. Final pretrial motions were due, and both sides submitted their witness lists and exhibits. The HOA's witness list was interesting. They planned to call several homeowners from the development to testify about their concerns regarding property values and neighborhood aesthetics. They also planned to call an expert on HOA law and community planning. Our witness list was simpler. Me, the county clerk Gloria, and an expert on Virginia property law. January 15th arrived cold and gray. The trial was scheduled in the same courtroom where we'd had our previous hearings. Judge Morrison presided again, which I took as a good sign. The trial took 3 days. The HOA's attorney, Marcus Webb, had clearly been overruled by his client because he presented arguments that Judge Morrison had already rejected. He tried to claim that the development boundaries created a presumption of HOA authority. He argued that allowing my business to continue harmed property values. He suggested that I was operating in bad faith by refusing to compromise. None of it gained traction with Judge Morrison, who kept asking the same basic question. Where's your legal authority to enforce covenants against someone who never agreed to them? The HOA's homeowner witnesses testified about their concerns. but Judge Morrison pointed out that their concerns, while perhaps legitimate, weren't a legal basis for jurisdiction over my property. Their expert witness, a professor of community planning, testified about the importance of uniform standards in developments. Denise tore him apart on cross-examination. "Professor, isn't it true that Mr. Bennett's property existed before the development?" "Yes, and isn't it true that people who purchased homes in the development could see Mr. Bennett's business was already there, I suppose, but so they bought knowing a propane business operated in the area?" "Well, yes." "Then how are they harmed by something that was already there when they chose to buy?" The professor had no good answer. Our case was straightforward. Gloria from the county clerk's office testified about my business license history and brought certified copies of all relevant documents. She confirmed that my license was issued in 1998 and had been continuously renewed. She also confirmed that the HOA wasn't formed until 2018. In your experience, does a business license issued 20 years before an HOA forms get superseded by that HOA's rules? Denise asked. "No," Gloria said firmly. "The business license gives the holder rights that can't be taken away without due process. An HOA can't just override county authority." Our property law expert, a retired judge named Henry Paulson, testified about the limits of HOA authority under Virginia law. "It's simple contract law," he explained. "An HOA's power comes from a contract. That contract is the deed restrictions and covenants that property owners agree to when they purchase in the development. If you never sign the contract, you're not bound by it." Mr. Bennett never signed any contract with the HOA. Therefore, he's not bound by their rules. What about the HOA's claim that filing development boundaries with the county creates authority? Denise asked. Judge Paulson actually laughed. "That's nonsense. Filing a plat doesn't give you power over existing properties. If that were true, I could file a document claiming authority over the White House and charge the president HOA dues." Even Judge Morrison smiled at that. When I testified, I kept it simple. I explained my family history with the property, my business history, my clean record with the county, and the harassment I'd endured from Patricia and the HOA. "Mr. Bennett, why didn't you just move your business to make this problem go away?" Webb asked on cross-examination. "Because this is my property. My father worked 2 jobs to buy this house. He taught me that if you own something and you're doing right by it, you don't let bullies push you around. I'm running a legal business. I'm not doing anything wrong. Why should I be the one to leave?" Webb didn't have a response to that. After 3 days of testimony, both sides gave closing arguments. Webb made a last-ditch effort to convince Judge Morrison that neighborhood harmony and property values should matter, but it fell flat. Denise's closing was powerful. "Your Honor, this case is about whether HOAs are bound by the same laws as everyone else. The defendant HOA wants special powers to control properties they have no contract with. They want to override county business licenses. They want to force people to comply with rules those people never agreed to. That's not how our legal system works. Mr. Bennett has proven beyond any doubt that his property and business predate the HOA. The HOA's own charter admits they don't govern pre-existing properties. This should never have gone to trial. We ask this court to rule decisively that Mr. Bennett is not subject to HOA authority and to award damages for the harassment he's endured." Judge Morrison took only 15 minutes to deliberate. When he returned, his expression was stern. "I'm ruling in favor of the plaintiff, Mr. Bennett," he said. "The evidence is overwhelming that Mr. Bennett's property is not subject to the Meadowbrook Estates HOA's authority. His business license predates the HOA by 20 years. His property ownership predates the HOA by 40 years. The HOA's own charter explicitly limits their jurisdiction to properties purchased after formation, or those that voluntarily join. Mr. Bennett falls into neither category. He looked directly at Patricia. Mrs. Henderson, your HOA engaged in a campaign of harassment against Mr. Bennett that was not only legally baseless but vindictive. You filed false complaints with county agencies. You contacted his customers with misleading information. You assessed fines you had no authority to assess. You violated my direct orders. This behavior is unacceptable. Patricia's face was rigid, but I could see fear in her eyes. I'm entering a permanent injunction barring the HOA from any interference with Mr. Bennett's property or business. I'm also awarding Mr. Bennett damages in the amount of $25,000 for harassment, defamation, and tortious interference with his business. Additionally, I'm ordering the HOA to pay Mr. Bennett's attorney's fees, which the court finds should be fully reimbursed given the meritless nature of the HOA's claims and their violation of court orders. The gavel came down. We're adjourned. In the hallway outside, Denise and I celebrated quietly. $25,000 in damages plus attorney's fees meant I'd come out ahead financially despite all the stress. More importantly, the permanent injunction meant Patricia and her HOA could never bother me again. How much were your attorney's fees? I asked Denise. About $12,000 total. The court will order them to pay it directly to my firm. You won't owe me a penny. This is incredible. Thank you. Thank you for standing your ground. A lot of people would have caved under the pressure. We walked outside into the January cold. Across the parking lot, I saw Patricia getting into her Lexus, Marcus Webb standing nearby looking relieved to be done with the case. Gerald and Lisa walked past without making eye contact. I felt something I hadn't felt in months, peace. But the story wasn't quite over. 2 weeks later, I received a check from the HOA for $25,000. Denise confirmed her fees had also been paid. The permanent injunction was filed with the county, becoming a matter of public record. I thought that would be the end of it, but then something unexpected happened. I started getting calls from other property owners in the area, people whose land also predated the HOA but who'd been bullied into compliance with HOA demands. A man named Frank Torres called first. I saw the court ruling online. I've been fighting with Patricia for 2 years over a shed in my backyard. She said it violated setback requirements, but my property is from before the HOA existed. Can they really force me to tear it down? Based on what happened to me, probably not, I said. You should talk to my lawyer. Frank did, and Denise took his case. Then came another call and another. Within a month, there were 7 property owners preparing to file their own lawsuits against the Meadowbrook Estates HOA, all represented by Denise, all making the same argument I'd made. Pre-existing properties aren't subject to HOA authority. The HOA board held an emergency meeting. According to my neighbor Tom, who attended, Patricia was forced to resign as president. The board voted to settle all 7 pending cases and to formally amend their charter to explicitly exclude properties purchased before the HOA's formation date. Marcus Webb, who'd been their attorney, declined to continue representing them. I didn't blame him. One evening in March, I was in my garage working on my truck when a car pulled up. To my surprise, it was Patricia. She got out slowly and walked toward me. I tensed, not sure what to expect. "Mr. Bennett," she said quietly. Her usual confidence was gone. She looked tired and defeated. I wanted to apologize. I set down my wrench. Okay, I was wrong about all of it. I thought I was protecting the neighborhood, protecting property values, doing what was best for everyone. But I wasn't. I was just— She trailed off, searching for words. I was just being a bully. I didn't know what to say. I stepped down from the board, Patricia continued. I'm moving away. My husband got a job in North Carolina, and honestly, I'm glad to go. This whole situation made me realize I'd become someone I don't like very much. Why did you push so hard? I asked. You must have known you didn't have a case. Pride, I guess. Once I'd started, I couldn't back down without looking foolish. So I kept pushing, kept escalating, even when I knew I was probably wrong. That was stupid. We stood there in awkward silence for a moment. I really am sorry, Patricia said. For what it's worth. Apology accepted, I said, and I meant it. Holding on to anger would only hurt me. Patricia nodded, got back in her car, and drove away. I never saw her again. Spring came to Fairfax County, bringing warmth and renewal. My business continued to thrive. The publicity from the lawsuit actually brought me new customers who appreciated that I'd stood up to HOA overreach. Several local news outlets had covered the story, framing it as a David versus Goliath tale. In May, I received final confirmation that the 7 other property owners' cases had all settled favorably. The HOA had paid each of them damages and amended their charter. Denise sent me a bottle of good bourbon as a thank you for the referrals. I was in my office one Saturday afternoon, catching up on paperwork, when my phone rang. It was Gloria from the county clerk's office. Xander, I wanted to let you know something interesting, she said. We just processed a mass withdrawal from the Meadowbrook Estates, HOA. 23 property owners filed paperwork voluntarily leaving the association. Is that unusual? Very. Most people stick with their HOA even when they are unhappy because leaving can be complicated. But your case apparently inspired a lot of people to realize they don't have to put up with HOA overreach. The Meadowbrook HOA is basically collapsing. After we hung up, I thought about that. I'd never intended to destroy an HOA. I just wanted to be left alone to run my business. But in standing my ground, I'd apparently started something bigger. Over the summer, I heard through the neighborhood grapevine that the Meadowbrook Estates HOA had formally dissolved. Without enough members to maintain operations or pay for common areas, the remaining board members voted to terminate the association. The common areas were deeded to the county, and the restrictive covenants were released. Tom Richardson came by one evening with a 6-pack of beer to celebrate. You know what this means, he said, grinning. I can put my basketball hoop back up. We laughed and drank beer in my driveway as the sun set, my propane truck parked proudly beside us, a monument to the simple principle that you shouldn't have to follow rules you never agreed to. The fall brought one final development. I received a letter from the Virginia State Legislature. Apparently, my case had caught the attention of a delegate who was proposing new legislation to clarify HOA authority over pre-existing properties. The delegate wanted to use my case as an example when arguing for the bill. I agreed to testify at a committee hearing in Richmond. Denise came with me. The hearing room was packed with both HOA representatives and property owners with grievances. I told my story simply and honestly. Small business owner, family property, bullied by an HOA that had no legal authority over me. Several legislators asked questions. Mr. Bennett, do you think all HOAs are bad? One asked. No, I said. I think HOAs serve a purpose for people who choose to join them. But the key word is choose. When I bought my property, when my father bought my property, no HOA existed. We never chose to be governed by one. That choice matters. The committee seemed receptive. The bill, which would explicitly prohibit HOAs from claiming authority over properties purchased before the HOA's formation, unless the owner voluntarily agreed to join, passed out of committee, and eventually became law. I received a signed copy of the legislation from the delegate who sponsored it. It hangs in my office now, next to my original business license from 1998. Life returned to normal, or what passed for normal. I delivered propane, serviced customers, maintained my equipment, and paid my bills. Simple, honest work. The kind my father would have been proud of. On the anniversary of Judge Morrison's ruling, I drove out to the cemetery where my father was buried. I sat by his headstone and told him the whole story. "I kept the house, Dad," I said. "I kept the business. Some people tried to take it away, but I didn't let them. I hope that makes you proud." The wind rustled through the trees, carrying the scent of fresh cut grass and distant flowers. I sat there for a while, just being present, feeling connected to the man who'd given me everything. Then I drove home to my house on Maple Avenue, where my truck sat in the driveway and my propane tanks rested safely in their enclosure. My castle, small and simple as it was. Mine by right, protected by law, defended by principle. Patricia Henderson moved to North Carolina and, from what I heard, never joined another HOA board. Marcus Webb continued practicing law, hopefully with less difficult clients. Gerald and Lisa faded back into regular neighborhood life. The Meadowbrook Estates development remained. Houses full of families, but without an HOA to dictate their every choice. I continued running Bennett Propane services from the same address where my father first taught me about hard work and integrity. Customers continued calling, tanks continued being filled, bills continued being paid, and every time I pulled into my driveway at the end of a long day, I felt grateful. Grateful for the county clerk who helped me find the documentation I needed. Grateful for the lawyer who fought for my rights. Grateful for the judge who enforced the law fairly. Grateful for the system that, despite its flaws, ultimately worked. But mostly, I felt grateful that I'd stood my ground, that when someone tried to bully me into giving up something that was rightfully mine, I'd said no. Not with anger or hostility, but with the quiet confidence that comes from knowing you're right. That's the lesson I carried forward. Stand your ground when you know you're right. Know your rights and defend them. Don't let fear or intimidation push you into surrendering what's yours. And maybe, if you're lucky, you'll inspire others to do the same. Years will pass, and I'll probably still be delivering propane in Fairfax County, still operating from the house my father bought in 1978, still running the business I started in 1998. The address will remain the same. The work will remain the same. The principle will remain the same, because some things shouldn't change just because someone with a clipboard and an inflated sense of authority decides they should. Some things are worth fighting for: property rights, business rights. The simple freedom to live your life according to rules you actually agreed to follow. That's what I learned from my war with the Meadowbrook Estates, HOA. That's what I'll remember forever. And that's what I'll tell anyone who asks about the time I fought City Hall and won. Except it wasn't City Hall. It was something much smaller and much pettier, but in its own way, much more dangerous. Because HOAs exist in that strange space between government and private organization, wielding power that can destroy lives while hiding behind the veneer of community improvement. My case helped establish clear boundaries for that power in Virginia. The legislation that followed helped protect countless other property owners from similar overreach. That's something I'm genuinely proud of, even though I never sought to be any kind of activist or crusader. I was just a guy trying to run his business and live his life. Sometimes that's enough. Sometimes simply standing firm in the face of wrongful authority is the most revolutionary thing you can do. The sun sets on another day in Fairfax County. My truck is parked in the driveway, ready for tomorrow's deliveries. The house is quiet and peaceful. The business is stable and profitable. Life is good. And somewhere out there, other people facing their own battles with overreaching HOAs are finding my case online, reading about what happened, and realizing they don't have to surrender without a fight. That knowledge, that legacy, means more to me than the $25,000 in damages ever could. Because at the end of the day, this was never really about money. It was about principle. It was about rights. It was about standing up to people who think their authority is absolute and showing them that it's not. Patricia learned that lesson the hard way. The Meadowbrook Estates HOA learned it the hard way. And hopefully, other HOAs considering similar overreach will learn it from their example. As for me, I'm just going to keep doing what I do, delivering propane, serving customers, maintaining my property, and living my life according to my own choices. Because that's what freedom looks like in practical terms. Not grand speeches or dramatic gestures, but the simple ability to work hard, own property, and make your own decisions without unjustified interference. That's worth fighting for. That's worth defending. And that's exactly what I did when the Meadowbrook Estates HOA tried to ban my propane delivery business and learned, through the county clerk's records and a judge's ruling, that my license predated their charter by 2 decades. They thought they had authority. They thought I'd back down. They thought wrong, and in the end, justice prevailed. Not quickly, not easily, but decisively and completely. That's how the story ends. Not with fireworks or celebrations, but with quiet satisfaction and the knowledge that when it mattered most, I stood my ground and won. The propane business continues. The house remains mine. The truck sits in the driveway, bearing my company name proudly. Life goes on, better and stronger for having been tested. And somewhere in North Carolina, I hope Patricia Henderson learned something valuable from our conflict. I hope she's living a happier, humbler life. I hope she's found peace. As for me, I have everything I need right here. My father's house, my own business, my hard-won freedom, and the satisfaction of knowing I fought for what was right and didn't give up until justice was served. That's the end of my story. The story of how an HOA tried to destroy my livelihood, how I fought back with the truth, and how the law ultimately protected the rights I'd earned through decades of honest work and legitimate property ownership. It's a story about America at its best. Individual rights protected, bullies defeated, justice served. Not a perfect system, but one that works when people have the courage to stand up for themselves and the persistence to see the fight through to the end. I stood up. I persisted. I won. And my propane delivery business continues serving Fairfax County from the same address where it all began, protected now and forever by court order and by law. That's all there is to tell. The rest is just living, working, and enjoying the freedom that comes from knowing your rights are secure, and your property is truly your own.